Hello and welcome to our lecture on reporting on crime with Journalism MO2, Digital Media, Reporting and Writing at Moore Park College. My name is Kelsey Stewart. So we're going to start off with a couple of crime coverage tips. First, we have recreate the crime scene. So what you want to do is you want to pretend that you were at the crime scene and you want to gather details as though you witnessed it. So you're going to walk through the actual crime. Secondly, you want to role play. Ask yourself, what would you want to know if you were affected by this crime? Thirdly, avoid the jargon. If you don't understand the term, chances are the reader does not either. Lastly, or fourthly, you want to go through the background of the case. So no matter how many days a crime story or trial continues, you want to make sure you always give a brief history of what is going on. You want to be accurate, so double check your story for accuracy and make sure that you don't convict someone of a crime before a judge does. Lastly, you want to investigate. Check out the public information site like sex offenders registries or research the subject's name in a local paper for any other offenses. So typically crime reporting is known to pack punch, be short, sweet, and gripping. One of the most best known crime reporters was Edna Buchanan. She wrote for the Miami Herald. One of her top headlines was Gary Robinson died hungry. It was a story of an ex-con who stood in line at a fast food place before he got shot down. So her stories always gave an essence of novelistic style writing, so it kind of set the scene. It always gave kind of pivotal details, and it kind of captured the humanity of the victim or the accuser within her story. That's the typical idea with crime reporting. You want to write about the people affected, and you don't want to focus on the authorities unless they're part of the crime or being affected. You want to just make sure that you focus on the human interest side of the story. So we have police rights. In regards to crime scenes, police have the right to protect a crime scene and limit access to the press, no matter what. It is their scene. But if you're on public property, reporters and photographers can get as close as the police will allow. This will probably benefit in your favor if you have created a network or a professional relationship of some sort with the police, with the sheriff's department, with your local authorities. If they know you, they respect you, and you've created that type of relationship, you're going to be getting more from a crime scene than your average media. If you're on private property, the access is at the discretion of the police or the owners of the property. The CPRA was established in 1968. It is the California Public Records Act. It requires that government records be made accessible to the public upon request, unless otherwise exempted from law. So if an agency receives a request to inspect an identifiable, disclosable record, the agency must promptly make that record available. If the agency withholds the records, then a member of public can seek a court order to enforce the right to inspect or copy the records sought, and they may even, not often, but they may receive payment for court costs and attorney fees if such a person prevails in a lawsuit. So criminal records. If you are trying to access the background information of a convicted criminal, or if you want to know where to find certain crimes listed or committed, then you would check your daily police log or blotter. This is linked to the Moore Park area, but if you would like to link something to your localized area, then you would have to research daily police log or blotter in regards to your city or state. But these blotters also list the names and natures of the victims as well as the nature of the crimes. So they're incredibly helpful for crime reporters. If you see or are able to find the police report, then you will see the arresting officer's name. What you want to do is first check with the public information officers before contacting the arresting officer, as there could have been multiple officers at the scene and so forth. So, previous criminal records. If somebody has been convicted of a crime, that court record should be available in court jurisdiction where the person was convicted. If the person was charged with a crime and found not guilty, or if the charges were dropped, that record is also public. What you will do is look up the court file number and the year of the court case, and you can look these up through the actual courts, or you can look it up through the criminal records. University records. So the Clary Act is in memory of Jean Ann Clary. Now, in 1986, Jean Ann Clary was a 19-year-old student who was raped and murdered in her third-floor dorm at the Lee University. After her death, her parents found that 38 violent crimes had been committed in the last 3 years on campus, but the campus was not required to divulge these stats. The Jean Clary Disclosure of Campus Security Policy and Campus Crime Statistics Act, known as the Clary Act, is a federal law requiring United States colleges and universities to disclose information about crime on and around their campuses. The act is enforced by the United States Department of Education. The Buckley Amendment to the Family Education Right and Privacy Act. So the Family Education Rights and Privacy Act, also known as the FERPA, was established in 1974, and this is also known as the Buckley Amendment. It is a law protecting the confidentiality of students' educational records. So the Buckley Amendment also allows students and parents of young students to access records and provides a process to request corrections to them when necessary. So if a school denies access to student records to a parent of a student under the age of 18, that's a FERPA violation. It's also a violation to deny the student access to his own records, provided that the student is at least 18 or is enrolled in a post-secondary institution. Records of juvenile offenders. So all states have laws restricting the release of records that identify juvenile offenders as people under 18. This can change if a juvenile is being tried as an adult, which is actually decided by a judge, or it will also change if the name of the juvenile is used publicly in court. So it will be a case-by-case basis. Use of names. So many news outlets do not release names of suspects in crime stories until they have been formally charged with a crime. So being arrested means only that someone has been stopped for questioning in a crime. The person becomes an official suspect after charges are filed in a court at a hearing called an arraignment.